We are devastated and feel betrayed with Judge Lowy's inability to give 3 consecutive life sentences without the eligibility of parole to the individual that took Colleen's life in such a horrific manner. We are disgusted and personally offended with the defense's repulsive recommendation that Colleen's killer be parole eligible within 15 years, therefore putting him back into society at age 29 to kill again. The defense's legal maneuvering is despicable and demonstrates utmost disrespect for our daughter and sister, Colleen's life. Evil cannot be rehabilitated. Today's sentence is unacceptable and the laws must be changed. Although we very much appreciate this court's commitment to seeking justice for Colleen, today's sentence did not achieve that goal. We recognize that Judge David Lowy was faced with a difficult decision, one that was unfairly restricted by the imprudent actions of the Massachusetts Supreme Judicial Court that decided juveniles who deliberately commit heinous crimes cannot be sentenced to life without parole. Colleen's family, friends, students, and those who admired her have been given a life sentence without parole, but not the individual who committed the heinous act. This is wrong and unjust. Today's sentencing does not conclude the legal process. The journey to ensure justice for Colleen has just begun. Because of the SJC restrictions, our family will be forced to attend parole hearings beginning in 38 years, which is simply unimaginable to us. We will have to relive that day with every hearing. As Tom and I age, Colleen's brother and sister, Dan and Laura, will assume this responsibility. However, we want to be very clear. At every parole hearing, our family's voice, Colleen's voice, will be heard.
Judges must have the discretion to impose a prudent sentence depending upon the circumstances. Based upon the testimony we heard in this case, we, and many others, believe that the juvenile mind is capable of distinguishing right from wrong. Each day, millions of juveniles go to school and learn and to be inspired, not with planned malicious intentions. The logic of the SJC is flawed and misguided. Therefore, judges must have the discretion to sentence juvenile offenders to life without parole, particularly in those cases such as this, during which undisputed and horrific evidence was presented. Although this individual parole amounts to cruel and unusual punishment for Colleen's loved ones, the notion of second chance should not be applicable in this case. Due to the intentional and thoroughly planned actions of this individual, Colleen cannot be provided a second chance, and neither should the individual who callously and without remorse took her life. The decision of the SJC is not only disrespectful to Colleen, but also to those who love her. The SJC's decision was a betrayal to all victims and their families. We are hopeful the governor and the legislature will recognize the great injustice imposed by the SJC and remedy this decision that extends rights to criminals and disregards the rights of victims and their families. While such an amended law will not provide justice for Colleen, it will protect future victims and their families. We pledge, as Colleen's loved ones, to apply the same vigor for life that Colleen demonstrated every day to righting this moral wrong.
The Ritzers are not going to take any questions at this time, and I ask that you respect that. They have